further signings. So it's all gonna turn into WISA.
Yes.
Right.
I think Ken mentioned something in the Calgary Act. It's about guardianship, succession, trusteeship, taking those positions.
But there's a reason for them consolidating all
All
this.
in one,
because
all in
nobody-
one position as executor.
Well, nobody has been
Occupying their office.
occupying their office and conducting the estate, so they've been doing administration, and they're now brazen. This is
Yeah.
a money-making operation.
What happened to the South Wales Consolidated? Oh, there you go. Talking consolidated.
Yeah, consolidated.
Does that emphasize consolidation?
Exactly.
What is CAFR's anagram, anybody?
Oh, CAFR?
Consolidated annual-
Consolidated annual,
First word, what is it?
consolidated annual financial
Reports.
fund, or report, CAFR, there you go.
So
CAFR
it's just
accounts.
ledgering.
That's the true bookkeeping, right, where the billions in the black and all the red.
No. The red exists, the black becomes new money under these insurance claims. And we are switching from the blue board to the black board. That which has happened has gotten us here. We've all heard of the term peacekeepers. Do they get funding to occupy that? You know what their account is?
Asher's. Oh, assassin.
If you do not listen to me and stay peaceful, I will make sure that this will happen. How come? Because I've been employed to do so. That's where we are. Anybody heard of Ray C. Dam? Anybody?
No.
Interesting gentleman, you may wish to do some research. He's now got entitlement to these new consolidated accounts.
And you see some type of character in...
Yes, he is in Europe and in North America. Who's getting indictments at this juncture? Anybody hear about Cheney's condition lately?
No? What's going on there?
Getting indictments, him and his family.
Oh, really?
When I say family, that's
The Bushes and that?
Carlisle Group.
The Carlisle group?
What's Carlisle Group do? Do they do military investment?
What will they do?
Military investments.
Ray C. Dam.
That'd be on the bid.
L-I, wow.
R-Y.
C-A-R-L-Y. L? Carlisle?
E. E on the end. Yeah, Carlisle. No, or sorry. The
Start
L.
again?
No, you just have
R.
to change the L to an E. L-Y-E.
Carlisle.
Carlisle, L-E.
Oh, okay.
We know
Carlisle.
who they are.
Yeah. The Bushes, Cheney, all those
Bin
guys.
Laden's.
Cheney.
Yeah, Bin Laden.
The 1.7 insurance investment to a $7 billion payout at the 911 Ground Zero Islamic Ground Zero. In the
Oh, this Islamic Muslim thing. Yeah, this is, I don't know if you guys know about this, but I don't know if they're the time is right now.
1536 French capitulation treaty. French. Capitulation treaty. They can take you, because you have a cell phone, and put you into international law and decide whether you will be tried under Islamic or Muslim law. Anybody heard of Qadai? Sharia law.
Sharia law.
This
Well,
is,
that's pretty brutal, isn't it?
this is what I was just telling Al, like any of these judges are not bound by the common law. They can pull from any law, body, mosaic, whatever in the world, can't they?
Yeah, but they've done something every year.
They've changed every year anyway.
Yom Kippur.
What is the day of Irav?
Day of what?
Irav.
Don't know that one.
It is the day before the day of Yom Kippur.
Well, the
And-
Erev Yom Kippur.
Excuse me?
Erev means
Erev.
the eve of,
Thank you. Okay. The eve of.
and Yom Kippur would have two T's.
I thank you. I appreciate correction. You cannot ask for forgiveness of God till you ask for forgiveness of the people. When you're going into court, are you creating contention if you don't have an instrument that takes care of the issue for you?
So you should actually be posting the instrument before you go in.
It is most likely viable to do so. Will you fold back into a military position if you don't put rackets around your zip code? Do you remember the article in the Vernon package that talks about the outlying islands?
Well, that came from David Clarence, and that's an issue for the United States, really, not so much Canada.
No, it's not.
Notional estates. I whipped that
I
out
think this
before.
is-
Notional estates.
This is an outlying island, right?
Yeah.
Right there?
Yeah, but if it folds back into the military, what is it?
It falls into their jurisdiction, that's for sure.
Oh. How we contract is amazing. Those invisible contracts waiting to, pull you from 49 and 51, just throw you right back to 49. You don't really have control. It's based on controlling interest of that contract. No says the qui trust. If we're not in that position, how can we maintain them? UCC puts you in what, as they say, first in line, first in time. It's an interesting quandary. I don't think I own anything. I have the right as a good steward to direct it for the benefit of others, but I don't believe I own my next breath even.
But that doesn't really mean what, that means that the estate, which is not you, it's just a property. So what was first in time? It was your corpus, your island. So that's what is first.
Yeah, and if
But
that's not
don't forget,
established
they
as a
have an
nation,
invested interest too.
yeah,
That's what we keep forgetting. If you go first in time,
yeah.
you still have to have consideration for them.
It's called running with the land for the benefit of the land. That's what the king does. It's the law of the land.
Right.
Yeah, but first in line and first in time refers to claim, not title. Claim on title, but not the title itself.
It's the right of entitlement to be in charge of the expense account.
Because you're now the creditor.
Yes.
And therefore the debtors have to acknowledge or deny your claim.
Correct.
Well, the estates are the creditors because that's where they're drawing everything from. They're bankrupt.
They're already escheated, so you're pulling the credit out to release it on the market, but they need to have somebody that has entitlement to do so.
And since you're not signing, or everybody hasn't been,
Oh,
they're doing it for you as a trustee.
Because you're
What's
absent.
that?
Absentee.
Absentee, yeah.
Absentee creates an open office for a legatee.
That's right.
Avoid.
And you go
Make sure
to
the
constructive trust, and we talk about that stuff. If you're in constructive trust, you're in assumption and presumption, and they can pick anything they want from anything they want because they're in constructive trust, assumption and presumption. You have to stay out of there.
That's the secret trust process.
Yeah.
There's nothing wrong
The
with it.
assumption and presumption, that's why they.
When you pull up to a stop sign, there's a secret trust obligation that you will do your part.
Yeah, secret trust.
This is, yeah.
All this stuff's on a presumption. If you don't object to it, you don't state it, they assume you waived that. And
That's
they presume.
That's all.
So immediately, if you're under the assumption or presumption that I've waived any rights here, you can just back off, right? Like right now.
Do
That's,
you really want to waive your rights?
Good question.
you didn't waive the rights though.
Gene Keating's affidavit of the executor starts out that we are before this court of record by special appearance by oath of office as executor without waiving any claims, rights, remedies, defenses, statutory or procedure.
That's a nice entry.
Now, that's the one thing that I was wondering about, and I spoke to a couple people, they said, no, I said, if you're going to be the executor, that's an office, shouldn't one take an oath of office?
Yeah, it says in the executive administrator's guide, the executor has to have an oath of office.
What if I didn't? I just went in and said, "You trying to push me out of office?"
Yeah. It's in the
Can
private.
you prove your office? Here's
Excuse
my
me?
oath. Can you prove your office? Where's your
This
oath?
is your question to the judge.
No, if you say to him, "Are you trying to push me out of office?" and he says, "Can you prove your office?" If you have an oath and you've signed it in front of a notary,
Okay, you go under one of the maxims, you lose. That's how I did him last night, threw him in jail for incompetent. It says very clearly, equity always, not sometimes, always wins over defendant. You're defending yourself, you're done. I got you, 21 days psych. You're, what do you call, absentee? Or just
if you walk in with your oath of office and you just hand it
What
up
do you
to
do,
the judge,
what do you have, they brought you in, they have the complaint, the duty, the burden of proof is on them, not you. You're going, you always, from ever since you were a child, we want to defend, we lose.
The other thing, the executive
Not
guy says the
defending, you're
executive is not
demonstrating.
obligated to produce
Call it
documents.
what you want.
Demonstrating.
We have to be careful. You can state,
Do you
I'm not
believe I'm
saying-
argumentative? I don't make statements.
yeah. See, if you're going to come in,
Correct me, I just did. You didn't see it.
I watch it.
He's so stuck on his interest in the outcome. That's okay.
But when you come in as a claimant now,
Yeah.
now the burden of proof is on you. Now you gotta come with this stuff.
That's
Well,
what
I
you just
try
said.
to just keep it in here because
Yeah.
as soon as I pull that
No,
shit
no,
out,
but it's in
go,
here.
oh.
But there's a difference between if they're coming in, you're a respondent, or if you're a claimant. We get them mixed up.
Valuable point. Valuable point. I think he just condensed his idea of expression. Would you repeat that?
Your
Yes.
point was no pleading is by way of question, so.
Please repeat what you said.
Well,
You're either what or what?
you're either the defendant or you're a claimant.
Okay.
But you've got to make up your mind and know that, or respondent. Respondent is different than a defendant again.
Yeah.
But you've got to state that, or it's on assumption, presumption, you're back in constructive trust.
SCR rules. I passed that to you last.
So you were going to say that
Come back
if
up
you were
here.
to present, are you trying to kick me out of office
Yeah.
without having any paperwork done? And the judge was to ask you, well, can you prove your office?
Can I prove my office? Is what you're
Can't
asking?
you? Yeah, if that was the question the judge would ask you, right? If you say, well, you're trying to kick me out of office,
I'd say, and when he says, "Can you prove your office?" Why don't you play judge for me?
well, can you prove your office? Yeah.
Can you prove I
Entitlement
can't?
to your office,
Can you prove I can't?
yeah.
There you go. Question of the question.
Why? Why not? Hot, cold, black, white. Da, da, da,
He
da.
did it right, he come back and
all I'm
asked him.
saying is that
Yeah,
if,
exactly.
where was it they said that an executor would have an oath of office? Where was
In
it?
the executive administrator's guide that was on the David Clarence website, I read it there, it says the executor should have an oath of office. It's not- I can't remember now whether it says must or whatever, but when I saw this, I thought about that for a while, executive oath of office, where is that? Then I saw this affidavit. And this affidavit doesn't say, I'm the executor, I'm blah, blah, this is my oath of office. This affidavit is about, in regards to a court case, and what Gene does is he gets into, well, you know Gene, he gets into everything here. We are, well, this is executor and executrix, so it's that we are the ground.
Is that more than 30 pages?
It's 43 pages.
You gotta drop it down to 30.
Well, Gene's got, because he's got all the codes, he's got everything in here. He's got, he copied it and pasted it right in the affidavit.
I've seen a short 3-page version of a trust agreement implementing ecclesiastical deed through a Eucadian registry time. Is that too much? Break that down.
Well, yeah, we're getting off this, we're getting off.
I'm gonna go through the whole thing. That's why I like a long board, so I don't have to. Eucadia.com. You may want to look at that. Anybody heard of ecclesiastical deed polls? Probably we all did just before the.
The thing about a deed poll is that it's good for rebutting any claim on title. For instance, Tim was looking at some of the international law that governs.
Yep.
Unum Sanctum 1213.
Mm-hmm.
Basically, the things in Genesis, there's this passage that says, the earth is the Lord's and the fullness thereof. So the Pope said, great, I'm his representative and I'm
Yep.
filing a lien against the planet,
Yep.
everything on it and everyone on it,
Yep.
which is rebuttable.
Yes.
Yes.
If you ask them to bring forward their claim. because I don't think God signed one.
No.
They couldn't get that participatory, it takes two parties, right?
But they've still asserted one, even though
Asserted.
it went unrebutted.
Oh, that's right, because he couldn't rebut.
Well,
Specifically.
we didn't rebut.
Well,
Okay, and
But as
because,
individuals, we can.
yes,
Yeah.
but because nobody rebutted, that's where all the
Trust
stuff, the stuff they did, putting non-whites into slavery situations, all this stuff started then.
Tucker Act.
Okay.
But
And,
hey,
I don't remember, I only got up to about a page 100.
Okay, the reason why less than 30 pages,
Good question. I read somewhere in an article that if you do fax 30 to the AG or the prosecutor, if you're whipping out 30 faxes, anything, or 30-page fax, anything under 30 is acceptable as being deemed on the day of received. Anything over that can extend or create a delay. It comes out of the 30-day overview.
The 3 again.
Unum Sanctum segued into the Church of England in the 1500s. So a deed poll sent to the Pope isn't
Yeah.
sufficient if you live in a British Commonwealth country. You have to notice the Queen as the head of the Church of England. And the deed poll, the way that Franco Collins wrote it, is not going to suffice for our purposes. Because what we're really doing here is we're taking not just title, okay?
Nope.
What we're doing is we're rebutting any claims
Yep.
and then establishing standing as executor over the estate. Then you have to take the corpus of the estate, being the man,
Yes.
the legal person title, the birth registration, and the government's liability. They filled out a physician's notice of birth.
liability or obligation?
No, the government created a liability for
Yeah.
themselves.
Yeah,
Because
so
they
it's their
created
own.
a physician's notice of birth, and they did it in admiralty, not under common law. And then they dealt with the cargo that was delivered, and they used,
Waybill.
well, it wasn't a way bill. It wasn't a bill of lading because it was by the recipient, so it was more like a.
Receivership.
Yeah, it was a receiver's tally,
Yep.
as opposed to a shipper's, trucker's load and counter, shipper's manifest.
Bill of
Because
lading.
they didn't know how much the baby weighed, male or female, they didn't know anything about it till it was delivered. So the dockman, the warehouseman, the dock warrant was issued by the doctor.
Yeah.
Okay, and if you check the birth registration, there's a few differences between a birth registration and a physician's notice of birth. And in BC, if you ask for it, they'll give you your physician's notice of birth on bond paper. I know somebody that got it, but you gotta go to Vital Statistics, you gotta demand it. In
How big is the
Alberta-
bond paper? Is it out of standard?
No, it was 8.5 by 11. But it was on bond paper. And a few of the specifics were, they asked for father's racial origin on both the birth registration and physician's notice. But on the birth registration, they want a nationality. On the physician's notice, it says white, native, other. That's all they want to know. That's their designation. They want a racial origin because that's how they designate their claims.
Tucker or Little Tucker?
Exactly.
No, you'll laugh, but there's a thing called a Tucker's
that's
Act.
exactly what.
Tucker's Act, okay.
Tucker's Act. You got the Tucker's Act. Natives can use that.
Other people.
Little Tucker's Act is for whiteys.
Really?
What was that?
Tucker Act.
Tucker Act. Natives can use that. Whiteys get to use the Little Tucker Act.
Uh-huh. I was just saying, that's akin to the reason why people,
White native.
well, as I was getting at, people's defined as free,
Yeah.
white, European descent.
Yep.
So if you know are not that, then you don't qualify as one of the people.
No.
Which is the United States Constitution.
And the second
Government
people.
of the people, by the people, for the people.
Yes.
And if it covered, you got a lot of rights in there. And if you were covered by it, you wouldn't need civil rights, would you?
No.
Obviously, you're not covered under the Constitution then if you've got civil rights. And you're not covered under the Constitution if you're yellow, red or black because you're not
Or if
free,
you
white,
didn't sign it.
European descent. You're not one of the people.
Yeah, you see, and that could be the Tucker Act and Little Tucker Act, depending on whether you're gonna get tucked or just a little tucked.
Yes.
Yeah. What was that? UCAR or?
Ucadia. Thank you for bringing us back.
Oh yeah, Ucadia, that's where you were.
That's
Oh,
one
yeah.
dash heaven.org.
Yes. At
UC?
At oneheaven.org and
One dash
Ucadia.
heaven.org or ucadia.org. UCADIA.
Okay.
Ucadia
.com,
has.
.org.
.org.
Or
Has anybody gotten their Euclidean time registered?
No.
Oh, so that's
They're what?
Euclidean time registered.
No,
It's almost like Cicadia, but it's Euclidean. More universal.
Yeah.
It's a universal registry. Are we dealing with electronic transfers nowadays?
Only pretty well.
So if I go to that site, as I've done, and I've converted my birth certificate time, my hospital time, and you punch it in there, and it'll give you 6 numbers dash, 6 numbers dash, 6 numbers.
666, yeah.
So it'll convert it in their registry that anybody else that I point out to, I have an antecedent repudiatory position. I pull up my treaty that says this is all my property and all the intellect is reserved. So I maintain the controlling interests.
Well, if you're gonna do a treaty, you don't have to do it through UK.
There's treaties that I'm aiming at that are in place that cannot be rebutted. None to do with Coca-Cola. We started out here.
He's got his Bible all marked up.
Sacrilege.
Yeah. This is section 7 of the Martins, so I don't know what it becomes yours. Which one you want to follow? Maybe we're all gonna get on the same page. Look how long that section 7 is.
Yeah.
And that's
Yes.
special. Did you know you got an aeronautical license?
Yes.
Good.
Do WGP 235770, but that's the public one.
Yes, it is. And if you're flying along against an internationally protected person, that would be yourself with your doors open on a vehicle. It's against your rules and theirs. So, section 7, it switches 6 to 7. It's offenses committed on an aircraft.
Yeah.
What's this?
Yeah, I looked at this. and I
Offenses
was-
committed on an aircraft, section 7.
Are you in flight when you're flying down a highway and your vehicle doors are closed? Yes, you are, because your feet are off the ground and you're moving, Bubba.
Wow.
So you're in an aeronautical flight unit and you got a freaking license because your straw man has made investments in NASA and all these other places. We do need Citrel and all these other contracts. So we go to section 7, and if you go to section 710, in any proceedings under this act, a certificate purporting to have been issued
Under the authority.
under the authority of what? The
Yes.
MOFA.
Minister of Foreign Affairs.
That MOFA. What do you read?
Is admissible in evidence without proof of signature or authority of the person appearing to have signed it.
Purported appearing.
And in the absence of evidence to the contrary,
Evidence.
Proof of the fact.
it is proof that the facts
Proof of the fact.
of the facts it states that are relevant to the question of whether any person is a member of the United Nations personnel.
International law.
Look how that's changed. See, this one says, is proof of the fact so stated, period.
What year?
1997.
Boo-hoo. Update. Say bye-bye to that. You need it.
Yeah, no, I gotta get a new one. I want it.
I'm missing something.
But
I don't see this.
Yeah, I'm gonna lead you on. Look, what we're doing is res gesta. Never mind. Res gesta. I have the right to enter this evidence to bring other evidence which is purported towards a statement that has been made. Follow us. We got that one. We're here. I need to get this to you. That's my goal in this meeting.
Oh, there's that.
So we, the
579.
Minister of Foreign Affairs, so
The, Attorney General.
maybe I'm jumping ahead here, but I'm seeing
Yeah.
this paperwork goes to the Governor
Because of
General
war.
and the Minister of Foreign Affairs.
In the
Yeah, now
public's
you're
best
thinking on a
interest.
proper, think
Because you
operating on an
treat
international
what?
level, nation to nation.
More obligation.
Secretary of State in the United States is who you
You've transferred the liability. They
United States.
reverse the onus. of
Oh, and
proof.
therefore, because the liability now rests on the Crown.
Crown Liability Act.
Okay, they don't want the liability, so in the public interest, they'll drop the charges.
Now it's risk management,
Yeah.
and under
That's
the
good.
Professional Conduct Handbook, the Professional Conduct Handbook, Chapter 12, Section 5 discusses violating Rule 4 if it's a marketing activity, in quotations, that is designed to take advantage of an individual physically or financially. Does this sound what we're always discussing? That is in their professional conduct handbook.
And we're what, lawyers?
Lawyers, judges, anybody that's in a professional position to conduct themselves with that degree of
Doctors.
authority.
Or starts understanding.
So does it become an issue when you put the liability on a lawyer, then they're saying that's gonna take advantage of an individual? And that's why they're gonna drop it? But,
It's in their rules. It's in the professional conduct handbook for the
so
law
they,
society.
as a professional courtesy, they're not going to create a liability on one of the lawyers, but if it's on us, they couldn't care less.
And they couldn't care less because the odds are you're going to abandon by your fear for a start. And in time, they will claim a 2057 tax.
This is reminding me again of that conversation with that prosecutor. I got rid of prosecutor after prosecutor until finally they brought in the DOJ Criminal Investigation Division QC as my prosecutor, and he had a meeting with me. He sat me down and he says, "Listen," he says, "my job isn't simply to seek a conviction. My job is to hopefully avoid a conviction."
Yes.
And he sat there and gave me this big spiel, and I said, "Oh God, thank God you're here, and thank God you said that." I said, "What's the remedy?"
Yeah.
And as soon as I said that to him,
You can't give me legal advice. Then don't. Give me the qualifying method.
yeah, he wouldn't.
Qualifying method.
That's simple, isn't it?
What qualifies
Because now
for
you're
a remedy?
denying me.
Yeah.
See, I reverse the onus and the liability once again. He's trying to be your friend, but he's just buttering you up for the bacon.
Yeah.
Hot potato liability.
Right.
Yeah.
Yeah.
Professional conduct?
Yeah. Law Society.
Oh, yeah, it's right on their website. Their
Violation of Rule 4. Punch it up.
I don't have a computer.
Go to the library.
what did you call
Rule
it?
4.
Violation of Rule 4.
Book itself.
Professional Conduct Handbook from the Law Society.
I don't know in Alberta if that's what they call it. I think it's Professional Conduct Handbook. I think it was a slightly different title. I think it was protocols or something.
Protocols, because
Yeah.
it's a question of probabilities and then it brings risk management. Everybody in the family is liable for the guy that's making a mistake. Close the gate or close the window, the bugs are gonna get in. Now the house is full of bugs because somebody didn't do a job.
It's not really a mistake if you simply come forward and reverse the liability. It's not really an error, but as a professional courtesy, they'll make sure he doesn't have to pay since you're not going to.
Is this designed to take advantage of me physically or financially?
Well, it might be designed to take advantage of that lawyer physically or financially, because also.
Only if I transfer the onus of liability by bringing the question.
But I would say, from my perspective, it was designed to take advantage of you. But only if you did not know your rights and responsibilities as
You know
an
what it's
executive.
doing? You know what it's doing? It's oscillating me in an emotive fashion.
Why?
Because without that impetus, I might just do nothing in life.
So you're saying they're doing you a favor?
It's hard to understand that our mothers did us a favor to teach us to cross at the corner at the light too. But it saved our head from getting squashed on the pavement, chasing the ball in all innocence between the cars.
Well,
Time and place for everything.
they haven't taught you how to reverse the onus so that you aren't going to be liable. have they?
No, but they're doing the best to put me in a position to be able to reprove those up and coming.
But they can't advise you.
That's correct. They cannot supplement.
Right.
Or supplant. They can only supplement. They cannot supplant, can they?
But you can ask.
Supplementation.
And we're so scared to ask because we already think they're bad.
You're operating under subrogation.
Yeah.
We will get it though, won't we?
You give it.
And we'll get it.
A get is a divorce.
Oh, that's right.
So we divorce
Give it.
ourselves from,
That's Hebrew law.
We give it, not get it.
Could I actually, if I surrender, I'm owed something. The value that I'm surrendering must be considerate enough to be returned in equal reciprocity. It's the law of reciprocity.
You know, it's interesting that word surrender as well, because it doesn't mean what most people think it means. It means
That's
like,
right.
making them liable for the debts, whatever
The valuable consideration.
Yeah, if you surrender something to them, then they're the ones that are now liable for it. Like the birth certificate, for example, you surrender it to the judge.
They're liable to do something with it.
Surrender.
They're liable to do something with it within 3 days if you don't give them the instructions what to do with it. What are they going to do with the liability?
Make it to their benefit, I imagine.
Ah, conversion law,
They have to though.
conveyance.
Yeah.
But if it's conveyed without permission, what is it?
Theft.
That's conversion, yeah.
Fraudulent.
Fraudulent, yeah.
That's why they took the lawyer's conveyance position away. And you got the secretary that gets a whole bunch of papers and goes, "Yeah, I think he thinks this way." Stamp, 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 stamp. Gazumping. And that's going to efflux the account. People are coming out now and saying, "Where's the note?" And mortgage pool bonds that have been sunk, the one that comes out that says, "Where's the note?" They got to go digging in the pool and pull that one out. And that affects the value of the whole pool.
Mm-hmm. Throws the system into
Disrepute, disarray.
Well, they have to pull it out of trade in order to remove the note and then put it back.
either.
And so at that juncture, what they will do is this. Create another delay, which introduces an option that can be claimed, and if it's not, then they just devalue the pool and sell it again. You're out of the picture. And it goes international. This is the new rules. This is the new
Oh,
rules. And I'd like you to read what that says right there to the crowd, please.
A new non-financial liabilities exposure draft is expected late in '09.
Did you say non-financial?
Non-financial liabilities exposure draft.
Does that sound like professional conduct issues? What's that word?
Professional.
What's the second word?
Development.
I'm in.
Yeah.
I don't like professionalism. I enjoy perfection in each moment and let it die so the next one can be born.
Mm.
If I hang on to this shit, I could be liable. If I push it towards the future to take care of everybody that's up and coming, I've done my duty. The lawyer is doing that because his percentage of income goes back to public interest. And he earns his position by doing pro bono.
Yeah.
So he's actually administrating from a behind a bar card.
A good faith position.
Yeah.
And so therefore he's in clean hands and good conscience.
Otherwise, he would be liable.
He's basically coming in and say, "I'll change the shitty paper for you. You just sit over there, don't worry about it."
Yeah, but now I'm going to charge you whatever I feel I want to for the diaper change.
Yeah.
Because you didn't reserve your position to corral my discretion. You didn't say, "Here's the bill." You fixed the price. Now wipe my ass.
Right. Yeah, I give you $1 for changing my diaper.
Yeah, you forgot to ask, how much would a job like that pay?
Instead of how much would it cost?
Yeah. How much would a job like that pay?
You almost caught that. It was right beside you. Thank you for
I
that.
used to do that to them years ago when, rather than accept for value, they'd say things and I'd say, "I'd accept that, but what's in it for me?
Conditionally agree upon, what are your terms?
What's in it for me? What do I get out of it?"
Yeah. Am I getting coercive punitive benefits?
Coercive.
I like that one.
Then use it.
I've seen a few.
That's all you get when you go into court. Do you know the end result of these investments? No. Are you going to be held liable for the end result that doesn't happen? I don't know if that's possible. But you can go to jail for it. But I don't think that's really where the liability stems or is measured, is it?
No, you can substitute that.
How?
7.1 substitution of a surety. For a surety. Or person for the prisoner.
Yeah. What I was aiming at was the understanding that we weigh our own situations with our
Is
conscience.
that in Martin's criminal code too?
What, 767? Yeah.
What's 794?
Oh, that's what they did when they give me immunity.
Do you want to read it?
In 794 it discusses
Right there.
exemption and exception. No reason to negativate the issue if exemption or exception.
We
Except
we inserted that
No
for a
need
fellow,
to
yeah,
negative
that says that
exceptions.
the Crown does not have to respond except by way of rebuttal. And the problem, of course, is if you're going into court, you can't make the statement for an exemption without testifying and giving them jurisdiction. So if you come forward as an executor and say, that is the exemption,
Good.
you know, then if they don't rebut, and they proceed to administrate anyways.
Yes.
Now they have gone into dishonor, they've breached and perjured their oath. And then you can go forward and you can demand that the Attorney General repair it, and when he doesn't, you inform him that he's got 10 days to fix it, or you're gonna send, here's a draft of the letter I'm gonna send the Governor General. And that's when you tell the Governor General to invoke the authority of the Provost Marshal, because now they breached and perjured, and if Her Majesty assents, then she has oppressed you to the point of civil rebellion. You'll be obliged to publish a solemn recognition against war. Good. And then you've made it a military matter. Now the Provost Marshal can come in and make sure that these people don't bring Her Majesty and the Governor General into dishonor by breaching and perjuring and injuring an ally of Her Majesty. And notice in this document they're talking about allegiance here. If you're in allegiance to Her Majesty, that's not an equal relationship. If you're an ally,
Alliance, yes.
if you're an ally, it's a lot different. But this talks about allegiance. I don't know who wrote this or who signed it, but.
Yeah, I read that one.
Just indicative of the options that are present on the open market. The Queen has a patent in Brunei, Jerusalem.
You can swear an oath of allegiance to Her Majesty and be an ally of the Queen or be a subject, but you don't have to be a subject. You can be an ally without consenting to be governed.
Well, an ally, that's really, being an ally.
A nation
well,
recognizing a
you're
nation.
not a subject, yes.
Yeah, you're
Can't be an ally
treat
and be a
that.
subject.
Yeah.
She's not an ally with enemies, she's an ally with friends.
Friends, and treason is between friends, which is why the military.
I like some of that, but I don't.
Military officers.
I'd like to have a copy of that, but there's some of that I.
Find a copier. I don't know.
We'll find a copy, we'll just make a stack,
I can email those to
we
you.
can
Kids
handle the
on it.
photocopy stuff, just we'll make a stack,
Yeah.
it'll all happen, all right? Just,
All
that's
right.
all we need to do, and we can make a copy for everybody, just put it.
If you go to the bottom of that, and you'll notice it's Supreme Court rules, civil rules.
Chamber proceeding.
Yeah. Can you send your paper? Thank you. Paperwork in to have it dealt with in the proceedings in the chambers.
Well, actually, I'd appreciate it if they would deal with it in private chambers. That doesn't
Okay.
have to go into court.
Okay. And I got a curious question. We're standing on a municipality bond because this building has a permit to operate. Is that correct?
Yes.
Does the Chamber of Commerce, just like a good bank, like a good court of equity, hold true to the same option? Can I pin the municipality and hold them liable for what the court is doing?
Yep.
Good. So can I get a remedy out of the Chamber of Commerce?
Point is like, are they liable for the court's actions? Absolutely.
Yeah. And so can I get a remedy? Can I go to the Chamber of Commerce and have a chamber meeting under my guise and control?
I don't know.
Why not? You could be the judge in there,
Well,
couldn't you?
if you
Wouldn't that go to
guys,
residential?
I'm just playing with something that just hit me in the back of the head now. That's
yeah,
all. That's all.
Yeah,
Just
but you're
hypothetical.
correct. When you look at the meaning of the word, go back to the meaning of the word court.
Yep.
Follows the sovereign is revenue wherever you go.
Yep. Court of equity is
Exactly.
always open.
Exactly what I
You're in
did
court
with
all the time.
the crown, when the crown prosecutor got up and started speaking, and I said, "Whoa, who is this and what's he speaking here? Who I want him to identify, for on the record, identify himself and his authority to be here and speak." And the judge said, "Well, the court is satisfied as to his identity and his authority." And I said, "This court sure as the fuck isn't. Now, I demand it. Cough it up now."
Yep.
And they freaked out again. And then, get him, take him away.
What if you just went, am I wrong to understand that the best way to get yourself in trouble, notice I'm not pointing at anybody, the judge and the prosecutor, and they're dead, so I ain't pointing, is to screw with the all caps name trust account?
That's in the executor letter.
Yes, it is. I'm not saying things here that you don't know.
So that, now I'm making you aware that I know. And that changes the rules
Yeah,
of the game.
that was the whole point. When
I
you walk in
produce
and
the
you
secret
say,
trust.
you say, I'm the executor and the testator, and if you think you're going to proceed, then you're doing it under Sesta KV trust law.
Would that cause you to get me to make a call against your behalf to risk management because of your unprofessional conduct? Just say yes, it's easier to think.
Oh,
Do you remember, Hank, Rule 144A?
144A, QSIP.
Yeah.
It's been a year.
You are a judge. You are.
Warrant and adjourn the issue.
It says right there, but people don't believe it.
144A QSIP, tie-in corpse.
I brought that
SEC.
stuff with me.
well, it's saying you're the judge.
Safe harbor, X. See? Although you're exempt, 12B. You're exempt, but nobody uses it.
We're at 7:10. We can deal with our issues when we enter in instruments that are testamentary, that oblige the system to comply with the will maker's instruction.
There you go. That's testamentary appointing you as officer of the executive.
Which proves I don't need a will, because what is a will?
And your living will, well, that's just your one for after
That's
death,
different.
That's all. Or a will is your sponsoring thoughts, I guess, your intent to how you want to do it.
Okay.
Right?
Okay, but the true definition in their world is what? It can only be implemented when.
You're dead.
So you're arguing against your will when you're alive, and it's proof of your incapacity.
There's two things that are involved.
But the testamentary document does what? Expresses the living will. Non-argumentative, non-contentious.
Express.
That's what I said. You express it, the living will.
So they're saying only
of the
the court
testator.
but there,
It's
it's
the
like,
testator. Your
Yeah.
testamentary letters.
Right, there it is right there.
Putting into words.
There's letters testamentary. a document
use
issued
a
by
modern-
clerk which
can
states
I
the
use a
authority of the
contemporary-
executor of an estate of a person who has died. Letters testamentary. This is one example of one, and it's by the testator. So who's the clerk in the court?
testator.
You
The
are.
testator.
Yeah.
Well, it's your call.
It's right
It's your
here.
paperwork.
So
If I use the word wish, is it equal to the word will?
Your wish is
No,
my
a
command?
wish
I guess
is,
it
a wish
is.
is a command, it's an imperative.
Yeah, but
Your
you
will
can't get me in
doesn't-
trouble in the corner with my incapacity of saying, please pay attention to my will.
That's what I mean, your will is just, well, it's not making it your wish.
But I brought it to contemporary modernism and say, respect my wish.
Well,
That's the
it's-
testamentary documentation. There's no argument at that juncture.
Okay, I want you to look here something. This is an instrument in writing granted by a judge or officer having jurisdiction of the probate of wills. Okay, if you're not dead, the will doesn't go for probate, but you are the officer having
But
jurisdiction
it
of the
is-
probate of wills if you're the testator and you're still alive.
It is, the decedent is dead.
Yeah.
The person is dead. So, and it's already been probated.
Well, then you're the executor,
Yeah.
and you would have conduct of the probate. That's all I can say, because you're the one who named the executor.
Right, well, you're the testator, that's what it says, the first thing it says there, the court, the court.
Codicils.
Okay,
Oh, got it, wills.
Documents issued by court of proper jurisdiction.
Well,
And then here it is done
What a
by
tangle.
the testator.
well, the court of proper jurisdiction is someone standing in their office.
well, that's the whole thing. If you walk into
Well,
court,
see, but this
it's
is,
still your court
Correct.
if
This
you're
is-
the executor and
this
not
is-
just a trustee.
How you walk into that?
this is by, it's coming by the testator.
Exactly.
And then this is signed by the court of probate court judge, or the probate court jurisdiction, which would be, and that's exactly what this says in here. It says that the executor derives his authorities solely from the will by which he is appointed, but not from the, yeah, right here. It is not derived solely therefrom in the sense that mere nomination in the will standing alone is sufficient to constitute one an executor. But the full powers of the executor come from the court of probate jurisdiction, which, recognizing and confirming the testator's selection, closed the executor therein named with plenary authority by issuing to him letters testamentary. So what we write is the letter testamentary, send them to them, and say, well, you got 10 days.
10
Yeah, but you
days.
see that, the thing there is what they're saying, like, estate law is governed by trust law, but directed by probate law. In other words, all the judge is doing is, he is rubber stamping, he is providing a verification.
He's meant to do what you're going to order him to do.
Yeah.
He worked for you once you're the executive. That's exactly
And
what
if you'll
you give him the
indemnify-
order, and he does it.
And if you'll
He
indemnify
does
it.
it.
Yeah, I didn't bring that.
Eh?
Which one? I don't think he'll do it.
Yeah.
By the letter of law.
One of those, the stuff out of Burnham there, one of the things, he wrote me an email there. And one of the gist of it was that there's nothing they won't do if you appoint them trustee and indemnify them.
Yeah.
Absolutely.
I went in front of the judge and I said, do you want us to go into chambers so I can indemnify the issue? He went beat red, kept his cool, kept a good bluff face, and said, I don't know what you're talking about. But yes. Once you lock them down with indemnity,
Yeah.
you subrogate their rights and defenses.
Right. See, the same with, right now, the trust is trying to open a trust account, and Carlton Weiss gave some directions on how to do that, and we attempted to do that. And
What
it
kind
didn't
of
work.
trust?
They just, an express trust.
Yeah. Ever heard of the term pure trust?
Yes.
Express
We're talking-
trust is a pure trust.
It is. We're talking about IRS 382 code issues, ownership issues. They understand you're trying to avoid taxes and you're trying to do it from a probate position. There's a conflict.
Well,
Probate principles.
the point that, what I was getting to there
Auditing.
was the way that we discussed now, and that Macker don't want to talk about too much, is that we did it wrong in that we went in and tried to open this account with those papers, where we had an authorized representative on behalf of the trust. So now what we're going to do is have the authorized representative send a package to the CEO of the bank with a $50 bill, photocopied, so we got a record for, as a deposit, to pay for everything, and a bond to indemnify them. And then they'll open the account, no problem, because right now they're just flat out refusing to do it, they will not do it. But equity compels performance, the payment's in there, and the bond indemnifying there, subjugated their rights, they're gonna open that account. Account's open, the registered mail number can be the account if they don't wanna play ball, there it is. We can make deposits right under that registered mail number.
Yes.
Yeah, see here, right here.
It's coming back through the post. People, maybe when we get together next time, there'll be understandings of what, remember Espavo was talking about?
Yes, maybe.
Raymond's account through the post office. They released that through Sussex.
UPU?
Yeah.
An executor takes his or her legal authority from the will itself, and these powers vest in the executor at the time of the testator's death. So even without probate, if you have the will and it says you're the executor,
Yeah.
you're the executive.
Right.
So this goes back to,
So how do you know you have the will? How do you prove that you have the will?
write it.
Made it up. Sure, you
Write it down.
Write
Like
it
I
down.
say, me,
Right, right.
What does it say?
ecclesiastical or common law. Okay, in granting probate, ecclesiastical authorities and later common law courts certified a document proffered as the deceased's last will was what it purported to be. So basically,
Testator, but now you're the executor. So you're gonna claim beneficiary at the end of the round. So you're holding three legs in the game.
well, beneficiary in the public, heir on the private side.
And so, how many names in a trust account? You gotta have 2 meetings of the mind and a place to keep the trust, which would be an individual or a financial institution run by the individual. There's 3 parties involved in trusts, minimum. Because 2 parties makes what? Just an agreement.
So you have a settler, a trustee, and a beneficiary.
But you're gonna be all 3. I said first.
See, that's what Gene's
That's what the clerk of the court
that's what
had.
Gene's affidavit gets into, sorry.
She called it a tri-order.
It's a tri-order because it's a tier judgment. A trier, excuse me, 3-layer judgment process. You got the judge, and the 12 invisible apostles that he's got to cut the checks for.
That's what
You
it is.
keep drawing ecclesiastical understanding into this, and you'll understand that you will calm down, and you will all come from here and not here when dealing with this. Because you're not wrong, And that's why you're going very righteously to get it done. I've had to curtail my attitude and keep my guns at bay too, buddy.
It's not easy, is it?
It's not when you know you are and they're being nice, is it?
Right.
But it is come to the time where we are uniting, and it is happening, it is unfolding, but we're making that happen. I'm glad to be able to do that. This is our Will Succession Act, and it does encompass, when I say ours, BC's, and it does have a section 59 for non-compliance of the will maker's instructions, and that makes them morally obligated, doesn't it? It does fall back to ecclesiastical. There's a sign behind the judge. It's written in French, but it has curlicue on the freaking letters, so I'm like, it looks like pig Latin. I said that in court, and I thought, oh, I should have done that. I got excited. I knew I was wild. It's French. And it says, Dieu est mon droit. God is my right.
Which?
God is my right. Dieu est mon droit.
Queen's claim.
But you're contracting between God, and you have to judge between you and God. Ecclesiastical affects probate, doesn't it?
It has to, yeah. Because
And so the
that's where,
Euclidean time takes their commercial world of my birth date and time, which is Gregorian, and I'll convert it back to universal, Euclidean, in a registry that they cannot deny that I'm no longer in probate, because I'm at an international will stage. That's where you're at with this. Global recognition through the UN. Were we at 710 with the MOFA talking about the UN? You stop there.
Oh, yeah. A member, whether the relevant question, whether any person is a member of the United Nations personnel.
Did you get a check from the military last week?
No.
I don't think you're employed.
No.
But you are under what is known as the HART Act.
Hard time.
Heroes Earning Assistance Retirement Tax from refugees from war-torn countries. Which country has not had a war on this planet? Have we ever had a one-world war or a two-world war? Oh, how many countries have been left out?
None.
HART Act.
Hard act.
Heroes Earning Assistance Retirement Tax. All these guys that died in the future, if I'm on, or in the past, and I'm unwelling now, their death certificates have been cashed out through the settlement market in Germany and remarketed under the gilt bond process, and I'm collecting dividends now.
Reconstruct.
Excuse me, yeah, dividends, not the derivatives, because Germany did the reinvestment,
Yeah.
and it's open for you.
The Marshall Act and all that stuff from 19. Okay.
so that's what they're investing in, basically.
Yes, because that's how the administrators file a POR, payment order request for administering your account.
Through what? Through the Marshall Act? Or
Through the CRIS. Court Registry Investment.
Where is this going to?
Where is it going to? Out on the market to be sold through the IAS process? I showed you that one already. Because of the NISA account.
Which you've abandoned.
Yes. Or you didn't implement the denial of the right to touch it. Or you didn't grab Form 106 and claim passing of accounts. I want a full invoice.
That's where your forensic audit will come.
Yeah, baby. You think he's going to backtrack to the end, to the beginning of the world and say, oh, here, look at my blue book, says the judge. He ain't going there. You can issue a estoppel by proof of claim pretty well most of the time, can't you? Where's my signed written agreement?
Right there, where's the authority to administrate the estate?
TVC,
Which,
true, verified, and complete. If you can produce the contract that has my signature, I guess I got no choice to follow it to the letter of the law.
That's not my signature.
Bingo, bango, anytime. I changed it. I like to sign with my left hand today.
Yeah.
X.
You get an X in the land titles office under the Spousal Protection Act. because you abandoned your property intellectually.
I feel like a stone skipping on the water. Over the years in court, battling with these battles, I go skip, 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 skip across a lot of this stuff.
And then blue.
That's today.
I know the blue.
Incompetent. Absentee.
It's just one invisible line from the not knowing to the knowing. Where that invisible line is your caliber of understanding. I don't set limits. I believe that I am unlimited. I do not disavow my knowledge of my immortal capacity. This too shall come to pass. We will fade to dust, but my spiritual side will continue. The limits we have are those we set. I'm a private, unlimited account. We talked about repository before. I'd like to set one up. It's 400 grand. Buy your bills at about 15% less. Cash out now, sell back at a go.
Can you say that again?
Repository. I want to buy your bill now. I don't know, 15% less, just like Gray Estates through Espavo. Tim.
Sorry.
Okay.
Espavo?
Yes. You've heard of his business, Gray Manor Estates, I think, is that the name?
Actually, I don't recollect getting into that with him.
All right.
Espavo. Are you referring to Espavo Sozo?
Yes.
Oh, okay.
Yes.
And that is?
William Glenn Canay.
I didn't know that part. He's
That
back.
is.
He's back.
That's perfect that he uses such an alias, because they would be scratching on his door, knocking it down.
Sir
I
Lawrence
used to call
Lugal.
him,
Yeah.
yeah, I used to call him Espavo Bozo, but
Okay. Well, he's been at it.
that's
He's got-
another time.
He's got a very interesting account running at the post office called Raymond. Did he talk to you about that?
No.
Okay.